This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. This is an important issue for anyone who has a claims-made policy. And they must understand that a threat of litigation is not a claim, and there must be a claim for there to be coverage under a claims-made policy. And a claim requires a demand for money, services, injunctive, or administrative relief. Homeland Insurance Company of New York issued Plaintiff, a claims-made liability insurance policy covering errors and omissions effective January 16, 2019 to 2020. Plaintiff Eqhealth Advisewell, Inc., formerly known as Eqhealth Solutions, Inc., a Louisiana corporation that provides healthcare management services to Medicaid agencies, commercial healthcare payers, third-party administrators, and self-employer groups, was sued in Eqhealth versus Homeland. The U.S. District Court for the Middle District of Louisiana on July 15, 2023, resolved a dispute about coverage where Homeland refused to defend or indemnify Eqhealth. Homeland issued a managed care organization errors and omissions liability policy to the plaintiff. The policy covered damages and claim expenses in excess of the retention that plaintiff is legally obligated to pay as a result of a claim. A claim was defined by the policy as any written demand from any person or entity seeking money or services or civil, injunctive, or administrative relief from the plaintiff. Plaintiff authorized the treatment for BN, a Florida resident in Oklahoma. One of plaintiff's contracts was to provide Medicaid management services to the state of Florida, and under this contract, plaintiff's primary operational contact was Florida's Agency for Healthcare Administration, AHCA, which is the state agency responsible for administering Florida's Medicaid program. As part of its contract, plaintiff reviewed requests for patients' Medicaid recipients to receive medical services outside of Florida. One such request for out-of-state services was a Medicaid claim by BN of Florida residents. BN was admitted on an emergency basis into non-party Brookhaven Hospital, a licensed psychiatric hospital located in Tulsa, Oklahoma. At the end of BN's initial 180-day period neared, Brookhaven submitted a continued stay authorization request to plaintiff, requesting an additional 180 days of inpatient services for BN. Plaintiff denied Brookhaven's request based on plaintiff's determination that BN no longer met the medical necessity criteria for the level of neurological rehabilitation provided at Brookhaven. Plaintiff's April 30 notice of circumstances email also contained a written timeline of events for BN's treatment at Brookhaven. On June 10, 2019, a lawyer with the Jones Law Firm representing Brookhaven sent a letter to Florida's governor, multiple Florida AHC officials, and a Medicare/Medicaid official. Brookhaven's June 10 letter discussed Brookhaven's disagreements with how Florida AHCA handled BN's claim. The lawyer stated that, quote, no lawsuit has been filed, at least as yet, close quote. The lawyer recommended to plaintiff that it review its E&O insurance policy to determine whether the letter triggers a reporting requirement. He concluded that, quote, this letter reasonably constitutes threatened litigation. Depending on the language of the policy, it may need to be reported, close quote. 6 months later, on December 12, 2019, plaintiff formally tendered the matter for coverage To do so, Plaintiff wrote a letter to defendant discussing the history of the BN matter and informing defendant that plaintiff had participated in settlement negotiations with Florida AHCA and Brookhaven and ultimately settled the matter in September of 2019. At the point of settlement, Eqhealth had virtually no choice but to settle on the terms agreed by AHCA and Brookhaven. Had Eqhealth refused, then the likely alternative would have been a suit by Brookhaven in federal court against AHCA and Eqhealth, with Eqhealth not having to indemnify AHCA for any judgments, but for all defense fees and costs. In order to mitigate the total exposure to all parties involved, Eqhealth agreed. The settlement agreement was signed by the last parties on September 20, 2019, and pursuant to it, Eqhealth paid Brookhaven $262,500. Defendant denied coverage on February 3, 2020, stating that, quote, no claim against Eqhealth was reported to Homeland. Eqhealth did not ask for consent to settle any claim, and Homeland did not provide prior written consent for the settlement or for any expense, payment, liability, or obligation Eqhealth may have had in relation to the matter. Therefore, no coverage is available for the settlement payment Eqhealth made to Brookhaven, close quote. The district court, reviewing the case, noted that Homeland expressly conditioned coverage of all claims under the policy on the filing of notice of a claim against plaintiff. While considering what constitutes a claim to trigger coverage under a claims-made insurance policy, the court relied on the Fifth Circuit that had instructed trial courts to differentiate the mere threat of a claim from an actual claim. The USDC concluded that despite the numerous communications between the parties and relevant third parties, no communication rose to the definition level of a claim such that coverage under the policy was triggered. Because the court found that none of the relevant communications prior to the September 2019 settlement between Brookhaven, Florida AHCA, and plaintiff constituted claims as defined by the policy, coverage under the policy was never triggered, since none of the communications sought money or services or civil, injunctive, or administrative relief. In my opinion, Homeland included in its policy wording a definition of the word claim. For the insured to obtain defense or indemnity, it needed to establish that a claim, as defined, happened. Without question, threats were made. A settlement was reached, and the insured paid money to fund the settlement. Yet no one made a claim as defined. The insured did not report the claim to Homeland until after it was involved in settlement negotiations. It didn't seek assistance or approval of its settlement negotiations. The insurer was not advised of the settlement, nor was it advised of the insured's intent to pay until after it paid, although the decision to pay may have been a wise business decision, since no one made a demand in writing that they pay for a cause of loss insured against. There could not be coverage triggered under the policy. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you found these videos to be of interest and use to you, please tell your friends and colleagues about them so that they too can subscribe to the blog or the videos, all of which are free. And if you found a need for additional detailed information about insurance, insurance claims, insurance law, and insurance fraud, please consider subscribing for a very small fee to my Locals Community or my Substack publication. Thank you for your attention.